Welcome to Holding the Line, a podcast about cops, courts, and crime. I'm LELDF President Jason Johnson, joined as usual by Sean Kennedy, our Director of Policy. And we're in our new studio. Isn't this awesome?
Yeah, I mean, the moving truck was huge, though.
Yeah, this is a very big deal. In a podcast studio, Holding the Line, Season 2, Episode 1. Sean, what are we going to talk about today?
I think we're going to talk about something that, we all loved as children, which was the Brady Bunch. I mean, the Brady list.
Brady list.
Brady list. We're going to talk about something else. Yeah, we're going to talk about something that's police related, but something a lot of people don't know about.
That's true. So, Sean, let me pose a hypothetical to you. Just get your reaction as a learned man who understands the general principles of our system of law. What if a public employee was subject to a process that was completely secret, like a black box? No one knew what was happening, but an allegation was made of some sort against a public employee. And as a result of that allegation, no due process, no notice to the public employee, no ability to challenge it or question what the allegation is. The public employee is suddenly deprived of serious, significant rights, including the right to continued employment without any due process. And they still don't even know why. Does that seem right?
No, and in most cases, those public employee unions have immense power to launch a grievance process, and there's legal action, recourse there. So in most cases, public employees have, in a way, outsized rights. Not only do they have the ability to access courts, they have internal disciplinary and appeals processes. They clearly have rights above and beyond certain private sector employees. They're merit system protections at the federal government and state level. So all of these systems are built in to our public employee system and our government that are basically to protect, and maybe in some ways is overprotect public employees' rights as to do certain things wrong or right, and to at least have their day be adjudicated.
Yeah. And in addition to any merit system protections or any union contracts that may apply, their employer is the government. So their government is subject to the Constitution, both the United States Constitution, the state constitutions, if they're a state or local employer. But somehow we actually do have this system that exists in the United States to this day. You've been leading a lot of research in this area, and you mentioned Brady lists earlier, but there's a particular case that we're working on here at LELDF that is like poster child for what can go wrong in the system that we have. And your research, I think, is confirming that we have a patchwork of approaches to this. But just let me describe the case. So it involves a former deputy United States Marshal named Corey Novick, and we've been working to support Corey now for, I think, probably close to a year now. Corey was at the time, he was a Metropolitan Police officer, Metropolitan Police of the District of Columbia, DC police officer. And he was a passenger in a car being driven by Detective Terrence Sutton. Anyone who's been paying attention to LALDF stuff knows Terrence Sutton is a separate case that we helped work with Terrence. And he was charged with second-degree murder. And the case where he was following a moped, the moped got struck by a civilian vehicle. Detective Sutton didn't do anything wrong, but he very vindictively was pursued by the U.S. attorney in D.C., charged with second-degree murder, ultimately convicted of second-degree murder, sentenced. But then I think President Trump's second day in office pardoned Detective Sutton. Well, Corey Novick was a passenger in that car, was never suspected of any kind of wrongdoing, certainly never suspected of any criminal wrongdoing or even administrative wrongdoing. He was a witness in the case. He was called to the stand by the government. He testified a series of times, both before the grand jury and in trial. We've looked at the transcript of the trial, and he never was impeached, which is the term that just means that he told the truth. They never showed that he didn't tell the truth. He was honest. He irritated the government because his testimony really didn't help the government's case. And we believe very strongly that as a result of that, the government went after him when the trial was over. And years later, Corey was working as a deputy United States Marshal at that point. And we believe that he was seen in the courthouse by a prosecutor that were mad at him. So what did they do, Sean?
They got him on a list, on a secret black list.
They put him on a list with no visibility. Corey still doesn't know why he was placed on the list. It's called a Lewis list in the federal system. It resulted in him losing his job. No due process, no hearing, no opportunity for him to even know why he was placed on the list. We still don't know why he was placed on the list. And this is, at this point, years later. This is what we're talking about. And this is happening across the United States. And it's a major problem. And fortunately, we've done some research on it.
Mm-hmm. Yeah. And one thing that because I love tangents, that relates to this, to give you a sense of how this whole thing was set up in a politically vindictive way, was the origins of it where Terrence Sutton and Corey Novick are in that car. And I believe it's in June of 2020. So this is a month after George Floyd, roughly.
Yeah.
This guy who has a long criminal history or whatever, Kyron Hilton Brown, is running away from the cops. He gets hit by that other vehicle. So an investigation takes place. DC has its own internal system. Obviously, there's been an officer-involved death, and it goes on. The U.S. Attorney's Office, which is the federal prosecutor for DC, and so it has all felony cases, basically is continuing its investigation apace or whatever. This is a serious thing. It's complicated. There's a lot of moving parts, whatever. A woman, also named Lewis, this is why I bring this up, goes and starts haranguing the U.S. Attorney's Office and goes public and starts banging the drum and brings out the parents or the mother.
I know where this is
going. Yeah. Guess who that woman is now? That woman, she is now the presumptive mayor of Washington, D.C. So this is going to go well, right? We're in the right thing. So another Lewis involved, her name is Janice Lewis George, who is a member of the Mamdani cabinet, sort of, is a Democratic socialist, called for defund the police, was one out there saying basically hang Terrence Sutton and Corey Novick from a lamppost or whatever. Like, they hate the cops. And that's who did this. And then we get what happens with Corey later down the road, which is we at least hear through the grapevine that Corey, when he was a U.S. Marshal, after he leaves MPD, right, he goes to become a U.S. Marshal. He gets hired. He's on probationary status. U.S. Marshals oftentimes take people to and from court. And in the federal courthouse, obviously, because it's a federal prisoners, all D.C. prisoners. And he's standing there, and supposedly one of the assistant U.S. attorneys who was involved in the Sutton case sees him in uniform. And then what happens? Corey gets a letter.
Yeah. He's effectively, like, at roughly the same time, he finds out that his employment's being terminated. And of course, as a probationary employee, he doesn't have the same rights. So he doesn't get, on the employment side, he doesn't get all the due process, which works great here because they don't want to give him any due process, because the reason that they're terminating him, he's also not going to get any notice of that. They just tell him, look, we found out that you're on this Lewis list, and it means that you can't work here. They didn't know. They're just like, all we know is you're on the list. You can't work here anymore. Every attempt we have made at the time, and then of course subsequent, to find out why he's on the list, we still don't know. We don't know. The entire process is secret. And there's no record of it. Certainly, Corey hadn't been given notice of it. The Marshal Service got notice of it, but Corey didn't, which also kind of tells you what was their real motive here. Was it to prevent some kind of grave injustice, or was it so he would get fired?
Well, and that's the case. So let's take a step back away from Corey's case, because Corey is sort of where we come into this as law enforcement legal defense fund. But where does the Brady list and the idea of Brady? What is this? What is Brady?
So it comes from, the name Brady comes from a famous Supreme Court case, Brady versus Maryland. Pretty famous Supreme Court case from the 1960s. That's what established the constitutional principle that criminal defendants are entitled to know exculpatory information. So anything that would tend to negate their guilt. So just anything, like, if a prosecutor became aware of an eyewitness who said that person didn't do it, or some forensic evidence that points away from the person who's been charged. And so that's a general principle everyone understands, well established in our law. And then later in the 1970s, there was another case called Giglio. I think it's U.S. versus Giglio.
Yeah.
Regardless, it was extended a little bit. So just like government witnesses, if they have issues with their credibility, then the defense needs to know about that, so that they can, if, for example, if there was a government witness, whether it's a law enforcement officer or any other government witness that had a history of perjury or telling lies or whatever, that the defense should know about that, because they want to be able to cross-examine that witness about their ability to tell the truth, the track record for truth telling. And there's been a number of other cases that kind of all run around that same principle. And that's basically what we're talking. So talk about Brady lists in the law enforcement context. It's a list that prosecutors put together of government witnesses, which are typically law enforcement officers, who have something in their background that suggests that that maybe their integrity has been questioned. So it could be something as obvious as like a history of making a false statement, a documented false statement, or it could be something a little bit not quite so obvious, like a complaint that's been made against the officer that hasn't even been investigated yet. We don't know if it's true or not, but even something like that in some parts of the country, in some offices, could have you placed on a Brady list. So it's basically a list of typically cops that the prosecutor has some reason to question their integrity, and therefore has to notify defense attorneys if that officer was involved in a case or is it government.
So I think what's important to think about when you do this is, first of all, it's a great first principle, which is that you as a defendant have the right to confront the evidence against you. And part of that is actually the positive evidence against you or for you, the evidence for you that you're somehow innocent and you should be, full transparency. So transparency, due process, all good things. But it also runs into something interesting about how the Supreme Court has operated for years now, sort of as operating as its own legislature or whatever, which is they created a right or an action or a principle, but of course they don't have the ability to legislate statutorily what that looks like.
Mhm.
So there's this why and what, but not the how. To Brady, there's we don't know what you're supposed to do. Here's what you're supposed to do. We know it when we see it, or we know when we don't see it in this case, which is you're not following Brady. But how you get to following Brady, we're not going to tell you.
Yeah.
It's also the secret.
Yeah.
So then over the last 20, 30 years, what has sort of evolved, it's not case law, but the evolved practice across the country where prosecutors they confront Brady.
Well, you can imagine the administrative difficulty if you don't have a system in place that, especially in big offices where, you at any given time, you have a big, significant number of police officers that are being investigated for something, because every time a complaint is made against a police officer, there is an investigation. Like that's just pretty typical. So how does a prosecutor, especially one in a larger office, keep track of all this? They've got to come up with some system, and they've all handled it separately. We're going to detail this in our upcoming report, but it literally is a patchwork of practices. So like one example that pops into my mind, which is what in Baltimore they call the do not call list, which always strikes me as kind of weird because the Brady list is not a do not call list. You still can call these people as witnesses. You just have to provide a disclosure to the defense. So that's there. But the way to answer your question, many prosecutors have solved it in a similar way. They establish a protocol for who gets put on this list. Sometimes the list is completely secret. Sometimes the list is completely public. Sometimes it's somewhere in between. Sometimes it's a case by case. So like every individual line prosecutor has to go in every single case and check any law enforcement officer involved in the case against this registry, for lack of a better term. But it's a patchwork. There's no one solution to this, but just about everything that we've looked at is problematic for law enforcement officers, no matter how they've resolved it. Just because, and we'll get into this, is although they're dealing with the criminal defendant's due process, and they should, again, we agree, Brady is good. There should be due process. You should know if there's some flaw in your case that you should use to defend yourself. The problem is on the other side. The procedures that have been used pretty much exclusively around the country do not provide any due process to the individual officers. An officer could be added to the list without notice, without an opportunity to even object, without an opportunity to appeal, without an opportunity to contest in any way, just no due process. That's the problem.
And it's not only no due process, it's not necessarily timely. The big issue is that, so you wouldn't necessarily hit the wall and say, okay, well, this is going to be determinative in this case. So we need to not only disclose it, but we're going to do a full investigation. So if that didn't happen, you could be on the list for some period of time, or why, or how, or something from your far back past has somehow gotten its way onto the list in the interim, but you've subsequently testified in 5 trials.
Mm-hmm.
And now, depending on the jurisdiction, what the prosecutor's motive is, or they could be retroactively notifying defense counsel that this guy has a credibility issue that we didn't know about, or we didn't notify you about, or where. So it creates this whole thing because there's no system. It's literally just patchwork. Right. And that patchwork has what we said is the first problem, I think, is transparency, which is we don't know who's on the list when they're on it. And then there's no transparency in the second level about how you get on the list. and what exactly constitutes your violation. Is it just that you have an asterisk next to your name? Well, some asterisks are bigger than others.
Sure.
You're a convicted, armed robber or whatever, or you convicted of assault or whatever, but for some reason kept your badge internally for whatever reason, or you've retired and they found out later, however it is, and they're calling you back to testify. Or alternatively, somebody said you lied about something on a traffic ticket once. And they couldn't, it was a non-sustained finding or necessarily no finding. It was a neutral finding. There was no evidence either way or whatever. And so that still goes in the file depending on the jurisdiction and whatever the criteria are. Is that in or out? Or it's a outright false accusation. Do you turn over the whole file with all the accusations? Some jurisdictions allow that, where there's a full file and there's no disclosure basically being acquitted internally or acquitted by an independent investigation. It doesn't matter. We're still going to print the affidavit from this, suspect who says you beat him over the head, even though he wasn't even there, whatever. So there's no criteria that's clear. Then there's no review process that's clear depending on the jurisdiction. So from prosecutor's office to prosecutor's office, who is actually making the decision? You kind of mentioned that it could be a line prosecutor doing it on an ad hoc basis. So it's like, oh, I've got this case. There'll be 5 officers testifying, and two others filled out reports that are not going to or be brought into evidence, but they're not still going to testify. So now I need to run basically background checks on all of them. And if for some reason something slips through the cracks and I missed something, or I didn't talk to the right agency because 6 months he was detailed to this agency and didn't get, all his disciplinary files over in time, therefore I missed something, that could blow a hole in my case, right? And then you go to the level of, so now the cop gets notified. What happens if they get notified? What happens? So I get put on the Brady list. Officer Sean, what happens next at a different agency? So,
yeah, well, I mean, it depends. Sometimes you might get added to the list because of something that the agency's aware of, that they investigated, and that, they took whatever the action was they took. Might have taken disciplinary action, or they might have closed out the investigation as like a non-sustained or like a neutral type finding, where basically it's like, just not enough evidence to prove that the allegation is true. They closed their investigation, and now if the local prosecutor says, well, you're on the Brady list, now the agency has to kind of be like, well, okay, we closed the investigation, we took the action we wanted, but now we find out Officer Sean may not be able to testify in court. And one of the things you really need to have as a law enforcement officer is the ability to testify in court. And so some agencies have taken the position, like the U.S. Marshal Service did with Corey Novick, that just being placed on a list, it doesn't matter whether it was proper for you to have been placed on the list. It doesn't matter if it wouldn't actually impact your ability to testify. Just your presence on the list is enough to terminate your employment. And that happens. It ruins careers. And that's really a problem. Kind of some of this is a little bit of inside baseball. We're talking about it. It's very technical, and for people who aren't actually working in law enforcement, it's kind of like, well, I really don't understand the big deal here. Well, the big deal is you have law enforcement officers who have done nothing wrong, who prosecutors have the ability to just add them to a list, not say why, and for that to have a really significant impact on that officer's career and future in law enforcement, even though they didn't do anything wrong. And the officer never has an opportunity to even correct the record or address the allegation at all. And that is, I think, for most Americans, problematic, because our system is based on fairness and due process. So like, if someone wants to make an allegation against you, whether it's a civil case, an administrative complaint, or a criminal charge, all of those 3 contexts, you do get due process. You get the opportunity to contest the allegation. In this, you do not, in the vast majority of circumstances. And I think that's the bottom line. That is the problem.
And one thing that's actually interesting about it. So to walk through it sort of as a recap is, you can be put on this list for actual wrongdoing, allegations of wrongdoing that were maybe overblown or whatever, sustained or otherwise. Pending allegations, and we were talking about this off camera a little while ago, which is the idea that just because someone files a complaint against you, sometimes the officer never actually got adjudicated internally. So it's not a non-sustained finding. It's an unresolved open case. And those are being disclosed. We were just looking at Kent County, which is Washington. They're disclosing those actively. They're ascribing it to a Ninth Circuit decision called Olson, where they basically say all pending complaints have to be disclosed to the defense. So that's just a he said without the other he said sort of thing. The complainant has now issued a complaint, and the officer is a liar and a cheat and thief or whatever he is. And there's been no formal investigation, but now the defense is allowed to impeach them.
So in that situation, Sean, in that particular situation where all allegations are being disclosed to the defense, if I am a person facing a serious criminal charge, robbery, for example, a drug possession, whatever it is, and I don't want, and Officer Sean is who arrested me, wouldn't I just get one of my friends to make a racial profiling complaint or something against Officer Sean? And that way, my attorney will get disclosed this allegation. And when you testify in front of the jury, he will be able to potentially be able to ask you questions about not just my case, but this other allegation, and make it appear that you're like a racist or unethical, corrupt, whatever the case may be, based on nothing, based just on an allegation that I manufacture.
And what's so interesting about that is one thing I talk about in the media narrative context or whatever, but it applies especially in court. And they always talk about this like stricken from the record. You watch the hour. That's such nonsense. And why it's nonsense? You cannot unring the bell.
Sure.
That guy killed my husband or whatever the wife shouts out. Like, that accusation stands, strike that from the record. Literally, the jury didn't unhear that. So if you call a cop a racist and you say, weren't you accused of blank, blank, blank on the stand? And you use the N-word and they like say it in court or whatever.
Yeah.
And even though you deny it, if you being shocked that you're getting called like a racist is now looks like you're guilty, right?
So my criminal case, if I'm a criminal defendant, my attorney would have the ability to turn it around and make it look like you're on trial.
Yeah.
Turn it into, let's talk about Sean's history of racial profiling.
You said you found drugs, but I heard you use the N-word already. So that kind of ability to basically impeach on non-sustained findings or just mere allegations, in this case, could be vindictive allegations by a criminal defense attorney. But there's another level to the vindictiveness here. So we go through the idea that it's a black box. So it's a black list that's in a black box. We don't know a lot about it, but we don't know the criteria. So how are they actually sussing this through? Which is sort of funny, I think, in an ironic sense that these are lawyers whose whole job is process and following like checklists to like make sure they get everything down. And they're, as we've now done, I've done 75 Freedom of Information Act requests, and I'd say a third of them come back with like either complete junk or we don't have a process.
Yeah.
One of the DAs straight up said to me, I just review them myself. Like, how do you review them yourself? Like, you're literally just going through, like, you're the elected district attorney for a major city, and you're hand reviewing officer files? Like, the arbitrariness, talk about a Brady violation. What if the defense found out that you just made this arbitrary decision to withhold something, and then it turns out there was no system being followed? So anyway, if that's arbitrary, how they put people on the list and for what is arbitrary. But the why is important here, because this goes back to what we talked about with Corey Novick, is because it's arbitrary or can be arbitrary, it can also be vindictive. And so we don't have any evidence of this, but there seems to be a motive behind why Corey was targeted for the Lewis list.
What we do have evidence of is there's nothing on the actual transcript that shows anything close to something that would require inclusion on any list. That's what we do know. The motives behind it, you're right. We can't
ascribe. It was speculated, but we know that they're accusing him of having impeached testimony, which is not true. Literally, there's we went.
Several people look at it. Like we're not the only ones looking at this. We've had a number of very experienced criminal defense lawyers look at it, and they're like, "There's just nothing."
And what's funny about the claim from the U.S. Attorney's Office to put Corey Novick on there is that it's actually repeatedly throughout the court transcript, and we went line by line through the court transcript, undermined by the judge. He says, "No, I'm not going to do that. I'm not going to do that. You're just making something that didn't happen. Like you're just alleging something that I never found or was never found in the court." And then they are just asserting it again. So it's just like keep saying it over and over again, and it becomes true.
Mhm.
And the problem is in a court setting where this judge, who was very hostile to Terrence setting,
Mhm.
it even found that Novik wasn't lying, or there was no evidence that he was untruthful. Um, they still have complete power to decide that he's been untruthful. It's just
Mhm.
arbitrary. And their motive is at least clear, that he embarrassed them. He went up to the stand and told the truth,
Mhm.
and they didn't like it because the truth hurt their case. And the irony is, it's talk about petty. They won. I mean,
Yeah,
they won, but they convicted both the officers, but they obviously there's a pardon issued by the president, but at the same time they won. And so we actually saw this in a series of other instances across the country. There's a number of instances out of Texas, but in Iowa a few years ago, an officer got put on the Brady list, and he found out after the fact when he either didn't get a promotion or was terminated under some kind of reform program that was put over about this. But there wasn't even a sustained finding. That the internal investigation by both, I think there was an Iowa State agency investigation and by the internal Department of Waterloo, Iowa, what it was, cleared him. But the prosecutor put him on the list.
it just didn't agree with it. They said,
They just didn't.
we know you investigated, but we don't agree.
And then what went forward was, he's like, this is consequence. I lost my job, or whatever I was going to think, I was going to lose my job. And so he went and he said, so let's adjudicate this. Where's my appeals process? And they go, we don't have an appeals process. You can't appeal this. And then it became a huge fight. And he did get sort of allies in the Iowa State legislature to put forward a series of bills. And then that even became a fight because the prosecutors fought back and said, you can't restrict our powers to put people on the list and all that sort of stuff. And that has actually just been resolved this in May, was the Iowa Supreme Court ruled for this officer and the new Brady law. But most states don't have any system for how you get added to the list, why you could be added to the list, how you come off the list, and who knows? Because one of the things we also saw was, it's not only did the officer not necessarily know until maybe it's too late, like in the case of Novik, where he gets that and he has no recourse, but sometimes these law enforcement agencies, depending on the jurisdiction, aren't even notified until something else. So like, we're putting you on the list, is just, now we have to tell you. And or for whatever reason, if they do tell them, and they just, Baltimore, let's use the euphemism "do not call" list. That's what they call it. Is they just don't call you, like they just don't. But that's actually an interesting question. If an officer is on one of these lists, would they? Is there a legal obligation for them to disclose if they're going to be a witness, or the evidence they produced isn't used, that they were involved in the case?
Yeah, if they're involved, there really should be a disclosure, because if, like, say, just for example, let's say that there was evidence recovered, or if there was proactive, let's say the case came from a traffic stop, and Officer Sean was the officer who pulled the person over. And even if you have other officers that could testify to the recovery of gun or drugs or whatever, the actual stop itself, if Officer Sean has an actual documented history of, let's just say, racial profiling or something like
Planning evidence,
that, then even the initiation of the traffic stop is something the defense gets to explore. And if you have a history of it, I mean, the defense could call you as a witness. And,
yeah, sure.
So yeah, it's pretty broad. It's, I guess, we're dealing with something where it's, yes, it is. I don't think anybody can take real exception to the fact the criminal defendant should have notice of this in proper cases. It's the other side. It has been complete. It's just a patchwork. It's, as you're finding doing research, that there's just very little consistency across the country. There are many jurisdictions that just ignore this, like as if it doesn't exist. There are others that, in my opinion, just use it punitively, maybe not exclusively punitively, but they do use it punitively. And then maybe there's a small handful of people that are actually doing it the correct way. They're trying to provide as much due process. I know there's some states with legislation that is geared toward providing the kind of due process to law enforcement that it should. Just trying to be fair, not trying to get law enforcement officers who do have integrity problems out of that, like not trying to help them, but the vast majority of law enforcement officers on the list probably shouldn't be on the list, and they should have an opportunity to contest it on the record.
Yeah, and I think the big thing that I've taken away from this whole process is that there are definitely, obviously, downsides, and Corey Novick's case is the problem. But the whole principle behind Brady is a great principle. The idea that the defense has the right to confront witnesses against it and see the evidence fully and fairly. And if that evidence, negates, as it says, negates the guilt or tends to favor the offense or whatever, they have to turn it over. It's discovery rules and all these other things. But when it comes to officers, they deserve the same due process in their when they're being accused of things. The defense is being accused of a crime. You're effectively being accused of dishonesty or a crime in the case of whatnot. But you didn't get your due process. You didn't get that. So there's no transparency, and the transparency comes in multiple levels: the officers level, sometimes the law enforcement level. Finally, it doesn't necessarily come out as to what the nature of the allegation is. You just know you're on the list, and it could be you stepped on someone's toe, or it could be that you're beating people on a regular basis and doing all these other horrible things, and scope isn't laid out. Who is the decider? Like we mentioned earlier, there's one DA who's the elected DA who's doing it himself. Sometimes it's ad hoc and it's a line prosecutor. In a lot of other jurisdictions, they have somebody who's like the Brady veteran, and that's their job, or they have a team or a committee and they go through it. And that's a very systematized process. Now, the question is, what they're actually deciding in those committees and on what bases is to be clear and fair.
So Sean, the research, I know you're still heavily involved in gathering all the research. You sent a FOIA request of like 75.
Yeah.
Prosecutors' offices getting a lot of that stuff back, and putting it all together, analyzing it. We're planning on issuing a report in the coming months to cover this topic entirely. And we're probably going to talk about it again this season on the podcast. They need to have a guest that's an expert in this area come on to the podcast. What else do we have lined up for this season, just in a general sense?
Well, we're going to do more probably on Soros prosecutors and the progressive DA stuff. There's been a lot of developments. We just had an election in Maryland where, they're back. And, there's some news out there about Soros funding some other political campaigns, but it's one of these topics that is worth coming back to. I think there's a lot of other things that we've covered in the past that deserve a revisit. One of them is what's going on with crime and homicide in America. We've seen a huge sea change, but a lot of people haven't really dug into what the numbers look like and mean. Police attrition is out there. And on this podcast, I think we're going to have a lot of really good experts in policing. People who are academics, who are themselves former police officers, some prominent former attorneys general, whether or not state or federal. And we'll have some other folks out there that I think are going to really bring a perspective on these topics that you won't get at many other podcasts, where there's a real law enforcement focus, but it's a broader context of what the criminal justice system looks like right now and how we got here.
Fantastic. I look forward to it. All right, season 2. If you're enjoying our podcast, feel free to leave us a 5-star review on your podcast platform of choice. And we look to see you back here next time on Holding the Line. See you next time.